Okay, go ahead.
All right, so our group is Group 9, and we were covering HIPAA, which is the Health Insurance Portability and Accountability Act. My name is Kelly, and we have Whitney, Travis, Leah, and Caitlin in our group. So, like I said, HIPAA is the Health Insurance Portability and Accountability Act, and it was signed into law in August 1996. It provides data privacy and security for everyone's medical information, and so those who are really required to follow law is those who work directly with healthcare information of individuals. So people who are part of health plans, providers like doctors, clinics, hospitals, and then anyone else who has access to that information, like claims processing or administration.
Okay, so HIPAA privacy rule. The HIPAA privacy rule establishes those national standards that all healthcare facilities must abide by. So it basically is the rules that all providers and such must have to go through. These standards protect patients' medical records and other personal health information. And anyone that deals with this protected health information must have those required physical, network, and process security measures in place. The HIPAA privacy rule establishes these standards by requiring appropriate safeguards to protect this information, and also sets limits and conditions on the uses and disclosures of this information without patient authorization. So an example of a limit on that would be that a patient's health information won't be given to an employer or for use for marketing or advertising unless it's obviously given by the patient. Who can see patient's information, those who are necessary for the patient's treatment and care. So the nurse who checks them in, the doctor, family members and friends that the patient has identified under their HIPAA privacy paperwork. So for example, I work at Rosemark, it's where I'm doing my internship at, and basically any patient that comes in has to fill out this paperwork, and only those listed on this paperwork is who we can talk to them about their records about. They can also use it for required police work, such as gunshot wounds, when protecting the public, such as reporting when the flu is in your area, and those associated with payment for the doctors and hospitals. Patients' rights. So the patient's rights that they have under this privacy rule is that providers and covered entities must comply with the patient's rights to ask to see and get a copy of their health records, have corrections made, receive a notice that tells the patient how their information is being used, decide if they want this information used for purposes such as marketing, get a report on when and why their information was used, and if the patient believes their rights were being denied, that their information is not being protected, that the patient can file a complaint with the provider.
The portability part of HIPAA is defined as being easily moved, meaning that when employees switch jobs or employers will lose their job or retire, that they are able to keep part of their pension and healthcare coverage, things such as their 401k plan. Part of the HIPAA plan is that they are able to keep their employer-sponsored health insurance if they're still continuing to pay their premium, as long as they are keeping up with their premiums and they're able to switch into their new employer's insurance. And that also includes their 403b plans, 401k plans, and health savings accounts. There have been many problems previously with pre-existing conditions, and one part of the portability part of HIPAA is that they are able to keep their insurance and are not denied for insurance solely because of pre-existing conditions if they previously had insurance for their previous employer. Flex spending accounts and pension plans are not included in this portability part of the benefits with HIPAA. And if they are switching insurances, there are certain circumstances that they are allowed to have. So they are covered outside of the normal enrollment period. They get extra coverage or get extra time to be able to sign up for insurance due to death, divorce of parents if they are under their parents, insurance, loss of a job between either them or their spouse, an employer significantly reducing hours where they are not able to afford the premium, and also moving outside of the area covered by the HMOs.
Okay, so under the portability portion of HIPAA, it's COBRA, and COBRA is an acronym for the Consolidated Omnibus Budget Reconciliation Act, which was actually originally signed in 1986. And this is a protection for individuals who are part of a group medical plan with their employer. And it provides them with a temporary extension of their healthcare insurance if needed. So, for example, if they're terminated or their work hours are reduced such that they no longer qualify for insurance, they can elect to carry COBRA coverage. And typically it lasts, COBRA, you can have it for about 18 months, but there are certain situations that it can go up to 36 months. So if you're enrolled in COBRA, HIPAA allows you to request special enrollment in a different group health plan if you have a special enrollment event, such as a marriage or the birth of a child, or if you have already used your COBRA, up to that 18 to 36 months, if you've already exhausted that, then, and you have another group health plan that you'd like to go into, you can go directly into it. Now, HIPAA provides limits on pre-existing conditions. However, the new Affordable Care Act prohibits group health plans from imposing any pre-existing condition exclusions. So before the Affordable Care Act, it used to be that people would elect COBRA coverage, so there would be no lapse in their insurance. And that would make it less likely for a new health plan to be able to deny coverage for a pre-existing condition. However, now under all group health plans, they can't deny coverage for pre-existing conditions from the Affordable Care Act. COBRA is very expensive because you assume the cost that your employer typically pays. So you're going to pay your portion, your employer's portion, the portion that your employer paid, plus oftentimes the 2% administration fee. So that's the total cost of your COBRA insurance.
The HIPAA violations and enforcement is broken down into two parts: civil violations and criminal penalties. The Department of Health and Human Services Office for Civil Rights is responsible for enforcing the HIPAA privacy and security rules. The OCR enforces the privacy and security rules in several ways: by investigating complaints that are filed with it, conducting compliance reviews to determine whether entities are in compliance, and then performing education and outreach. Failure to comply with HIPAA can also result in civil and criminal penalties. If a complaint describes an action that could be a violation of the criminal provision of HIPAA, OCR may refer the complaint to the DOJ for investigation. With civil violations, in cases of non-compliance where the entity doesn't resolve the matter, OCR can decide to impose money penalties to the covered entity. And the chart to the right shows how all that is broken down, determining how much neglect was caused, decides what the minimum penalty and the maximum penalty are, just like for normal criminal violations. With criminal penalties, the violations of HIPAA are handled by the Department of Justice. And as with the civil penalties, there's different levels of severity for criminal violations. Covered entities and specified individuals can face a fine up to $50,000 as well as imprisonment for up to 1 year. Offenses committed under false pretenses, which, having worked in a law firm for 4 years, happens a lot. It can be increased to a $100,000 fine with up to 5 years in prison. And if the offense is committed with an intent to sell, transfer individually identifiable health information for a commercial advantage, so trying to use that information to get gain, or maliciously harm somebody, it goes up to $250,000 and imprisonment for up to 10 years. So it's pretty serious stuff. And the covered entities, deciding who is covered is a big part of what it determines whether you have to pay those big fees. But they're directly applicable to covered entities, including, like was covered a little bit before, health plans, healthcare clearinghouses, providers who transmit the claims have to be careful, and even prescription drug card sponsors. So directors and employers or officers of the CE may be directly liable under HIPAA in accordance with corporate criminal liability, where an individual CE is not directly liable. So they can still be charged with conspiracy or aiding to the crime.
And these are our sources here. And that concludes our presentation.
Awesome. All right, great job, you guys. You covered the topic really well. HIPAA, as we've already talked about, is obviously a very important law that's in place to protect our privacy and keep that information safe. I mean, if you work at a hospital or in any healthcare organization, you understand how serious it is and how seriously they take those breaches. So you guys did a really good job of covering that. Normally, I'd ask you guys a question right now. I'm just asking what the most interesting thing was to learn while you were studying this. But I did tell Travis I'd have him out of here by 10 o'clock his time, and it's just barely turned 10 o'clock his time.
You're welcome.
So, I'll go ahead and stop the recording, but hang on for just a sec.